Part of our 36 family series of seminars about financial remedies cases in the current situation of COVID-19. In this short video, we're going to be looking at private FDRs as an alternative to court-based FDRs, including why you might want to have one, how to prepare for them, what it entails, and particular things to be aware of in conducting remote private FDR hearings. I'm Marissa Allman, and I'm joined by my colleagues Rhys Taylor and Andre Boyarsky, who are both finance specialists and arbitrators as part of the 36 group. So, and I'd also refer you to Rhys's extremely helpful article, which has been published by LexisNexis on the question of private FDRs, which pretty much tells you everything that you need to know. I do find, however, that many of my solicitors, even if they are matrimonial specialists, have not had experience of conducting a private FDR, and so we thought it would be helpful just to produce this short guide to help you to navigate your way through it. And particularly in circumstances at the moment where courts such as the Central Family Court are pretty much avoiding having any hearings at all unless the parties have exhausted all opportunities for alternative dispute resolution, including private FDRs and arbitration. There's also more than the usual amount of uncertainty at the moment about whether a case will be listed for an FDR or a final hearing for that matter, who it will be listed before, how it's going to take place, what sort of time the court will allow for it, and whether it will be deemed suitable for a remote hearing. And those FDRs that do take place are often taking place by telephone, which brings its own constraints at the present time as well. Having a private FDR offers the parties the opportunity to regain control over many, if not all, of these factors, and to endeavour to reach real agreement with the benefit of an experienced practitioner who can guide and support the parties with an early neutral evaluation in the circumstances of the current pandemic. I'm going to hand over to Rhys now, who is going to tell you more about what a private FDR is and how it differs from and fits within the court process. Rhys.
Thank you very much, Marissa. So far as how it differs from a court FDR, it's very similar, in fact. The chief difference is that we've all seen the court FDR lists with perhaps 6 or 7 FDRs in the list for the day, whereas a private FDR, you have the attention of the tribunal exclusively for the day. That obviously means that the tribunal has had more time to read the papers, has more time to hear submissions, and can give a little bit of time to thinking about the indication, and can give a longer and more thoughtful indication if that assists. So it's nothing unusual or strange. You're very used to doing this kind of thing. You're just doing it privately rather than in the court process. I think the key thing that one needs to have a commonality between the court process and the private FDR is the question of impartiality. Judges are impartial. Now and again, it's very rare that a recusal application is made because for some reason they're thought to not be impartial according to the tests which have been set down. So far as a private FDR is concerned, again, the tribunal needs to be impartial as a matter of law. That doesn't stop, for instance, me appearing before Andre. People who are in the same chambers can appear before one another, but there'll be some circumstances where the relationship between the practitioners and the private tribunal is such that that relationship would have to be disclosed prior to the tribunal proceeding. So that's really the main things you need to have in mind so far as what a private FDR looks like. It's a private, impartial tribunal. Secondly, how does it fit in with the court? Well, if you can get a first appointment or you're agreeing directions as part of the accelerated first appointment procedure, you can provide in your first directions appointment that there will be a private FDR. And there's some merit in doing that. And certainly before the crisis, there's some merit even in the court directing when a private FDR will take place, to make sure that things proceed according to the court's timetable. But it may be that there aren't directions, or there aren't even proceedings. The parties can simply contact people who are holding themselves out as providing this service, set up a private FDR, and it can take place usually at quite short notice. Certainly in our chambers, we have a short standard terms and conditions, which we invite people to sign, very much like you would sign in a mediation agreement. After the private FDR, providing that has taken place and the court is satisfied it has taken place, and if the parties have not been able to agree, the court then would not require a second court-based private FDR. The court wants to know, was there a private FDR? Who was the private FDR tribunal? Who are the advocates in the case? And that offers were made on the day, and providing the court is satisfied of that, it's not likely to inquire further, and it can be listed for a final hearing if that is what the parties need.
Thank you, Rhys. It's not difficult at the moment to find people who are willing to conduct private FDR hearings at all levels. There are a number of retired judges, in fact, who are also offering private FDRs for the most complex level of cases ordinarily, right down to relatively junior counsel for the more straightforward cases. Certainly, this is not a remedy which is limited to high net worth or complex cases. And the most important thing is really to choose the level of individual who is appropriate to the complexity and proportionate to the money involved in your particular case. And as Rhys says, to find somebody who's going to be impartial and that you have confidence in as a private FDR judge, and that your clients can have confidence in and find to be empathic and who will give the case their full care and attention. Andre, could I ask you to tell us something about how to prepare for a private FDR?
Yeah, well, as Rhys said, the similarities between the private FDR and the court FDR are probably greater than any differences between them. So the way you prepare for it is really going to depend on where you are in the process when you decide to go to a private FDR. If you're already in the court process and have already had a first directions appointment with directions towards an FDR, there's no real difficulty in simply switching straight into the private FDR process, using those directions as the preparations for it. You'll still then, in preparation for the hearing itself, prepare a bundle for the evaluator, the private FDR judge, as well as for the parties, skeleton arguments or notes for the hearing prepared by the advocates in the same way, all sent to the evaluator instead of being sent to the court. If you haven't yet started a court process, or you haven't had a first appointment, of course, then you're going to have to sort out the practicalities of disclosure and everything else that's required to get ready for a private FDR. Hopefully, parties, by the time they're agreeing on a private FDR, will already have dealt with disclosure on a voluntary basis, done questionnaires on a voluntary basis likewise. If they haven't, then of course you've still got the option of trying to agree directions to deal with all of that with the other side. Failing agreement, there's no reason why you couldn't think about even taking that discrete specific issue, if not to the court with the current problems that there are, then to an arbitrator, just to arbitrate the question of evaluations, directions over questionnaires, and so forth, in order to get the matter ready for a private FDR, and then go to the FDR at that stage. The bundle I mentioned earlier on will need to be prepared. There's no restriction on size because the FPR don't apply to the private FDR route. But do bear in mind that the more you put in the bundle, if it's material that the FDR judge doesn't really need to read, there may well be implications in terms of how much he charges for looking at those documents. If it wasn't really necessary to do so, you can save that money. So really, the similarities are greater than the differences in that respect, and it shouldn't be too difficult for practitioners to shift into private FDR mode rather than using the court as an alternative. Rhys, do you want to maybe now talk about what happens on the day?
Yeah, so, well, there's two different days, aren't there? There's the pre-crisis day, and then there's the remote day. I'm just going to talk very briefly about the pre-crisis day first, if I may. You would ordinarily attend at a chambers or a solicitor's office. You would usually attend relatively early, 9 o'clock, so that the parties have got the time for the usual discussions which take place. You can expect your tribunal to be quite relaxed about allowing you time. So if it's notionally listed to start at 10 or 10:30 and the parties need till 11:30, that's really not going to be a problem. The tribunal is not trying to get through a list. The tribunal is just there for you and will accommodate you. The parties can then come in, very similar to in court. You'd probably address the private tribunal as sir or madam. There's that level of formality. It's as you were in the courtroom, as it were, and submissions can be made. My experience is that those submissions can be a little bit longer because, again, you're not under so much time pressure. The private tribunal may well take a few moments to gather their thoughts before the indication is given, and then typical fashion, the parties will go out for further discussions and can come in for further indications and refinements later on in the afternoon if that's required. And then the other beauty of a private FDR is come 5:30, you don't have a security guard coming along to tip you out into the road because they want to shut the court. And you've also got at your disposal chambers facilities, printing, refreshments, all of those kinds of things. So that's that's how it is pre-crisis. I don't know whether, Andre, whether you want me to talk about remote hearings or whether you'd like to deal with that.
I'm happy to talk about remote hearings. I've done a couple already, so I've had a little bit of experience. Clearly, remote hearings do present some challenges. It's not as easy as everybody being in the same building and working face to face. Clearly, you could do this by way of telephone or video. Without doubt, video works better than telephone, and that's certainly the preferred route we've been using in chambers. We've been using Zoom video conferencing, which seems to work very well with a dozen or so people working online at the same time without any real difficulty whatsoever. Clearly, everybody does need to have at least a decent broadband connection in order to make it work, but Zoom certainly seems to use relatively little bandwidth, so you don't need to have a super fast broadband service for it to work reasonably well. And I've done at least one case where one of the parties was joining on a mobile phone using only a data signal on a 4G connection, which seemed to work perfectly adequately. So those are easily sorted out, and we in Chambers sort out the Zoom arrangements for everybody. Everybody's just got to link in. But the parties do need to think about some things that aren't a practical problem when you're at court, which is the practicalities of how you're going to take instructions if you and your solicitor and the client are all in different locations on the day of the private FDR. So it's helpful to have either a separate video conference link set up, which allows you to have a conference outside of the private FDR securely and in privileged fashion. At least one of the ones I've done, we set up a WhatsApp group for messaging between each of the users during the hearing itself, and also outside it, which was useful in the event that the link on the video link broke down at any stage, but also so that the solicitor and client could give me private instructions via WhatsApp messages whilst I was acting as an advocate in the private FDR. So do think about how those things which we do very, very easily in court just by whispering behind a hand can be managed when you're in different locations and working through remotely. And finally, I suppose the lawyers have also got to think about how they're going to communicate with each other when it comes to the negotiating phase, both before and after the private FDR hearing itself. Phone or email are probably going to be more than adequate, but again, you might want to think about sorting out a separate video conferencing room just for that meeting to take place. There are facilities within Zoom where the private FDR judge can control all of this. Personally, I found it a little bit clunky, and it's probably better to have your own arrangements set up on each side to make sure you're independent of the private FDR judge when you're dealing with that. So anything either of you two want to add on remote working?
Well, there's one thing I'd mention. One of the private FDRs where I sat as the private tribunal, I had a screen of people in front of me, but one of the parties was very animated indeed. Now, in fairness, we'd all agreed to mute, so all I could see was people's impassive faces, save for this one person who was vigorously shaking his head and waving his hands around. And might I suggest that as you pop into court, you quite often say to your client to just be quiet and to not gesticulate. That's something that's worth remembering on the online call as well.
Thank you, Rhys. The other thing I would mention is to say that applications such as Zoom have the facility to be able to share documents. So if your private FDR judge, for example, is looking at net effect schedules and things like that, you can have the same documents up on the screen at the same time so that everybody can see them and compare and contrast, and that's quite a useful feature as well. Anything further from you, Andre, before we close?
No, thank you.
Very well. Well, thank you all for tuning in. I hope that you found this useful. Do please have a look at our other YouTube videos on topics affected by the coronavirus pandemic, in particular Barrel and Barter jurisdiction, pensions on divorce, and our short guide to arbitration. Thank you and goodbye.